My brother called me a charity case in front of a room full of people. I didn't say a word. I just looked at him. And I smiled. He thought that smile meant I had nothing left. He had no idea it meant I had already won. Let me back up. My name is Vivian. I'm 31 years old. I grew up in a 3-bedroom house in Columbus, Ohio, with a mother who worked double shifts at a hospital and a father who spent most of my childhood reminding me that my brother Nathan was going places. Nathan was 4 years older than me, sharp-tongued, charming in the way that only people who've never been told no can be. He knew how to walk into a room and make everyone feel like they needed him. Our father loved that about him. I think my father loved it because he recognized himself in it. I was the quiet one, the one who got good grades without anyone noticing, the one who applied to college without telling anyone until I got in because I didn't want to deal with the conversation if I didn't. I studied finance at Ohio State, worked 2 part-time jobs to cover what my scholarship didn't, and graduated with honors at 22 while my brother was already 3 years into running a mid-sized logistics company our father had co-signed a loan for. When I graduated, my father threw Nathan a dinner party to celebrate the contract Nathan had just landed. My graduation wasn't mentioned. I moved to Chicago. I told myself it was for the job opportunity. It was also because I needed to breathe. The job was at a regional investment firm called Callaway Group. I started as a junior analyst. I worked until I understood every instrument they traded, every client relationship, every risk model they used. I wasn't aggressive about it. I was just quiet and present, and I learned everything I could. By 26, I was managing a small portfolio. By 28, I had a track record that spoke clearly enough that 2 of Callaway's senior partners asked me to co-found a separate private equity fund with them. I said yes. The fund was called Meridian Capital. We started with $12 million in committed capital from 3 institutional investors I had cultivated over 2 years. Within 18 months, we were at $47 million. We didn't chase flashy deals. We looked for distressed businesses with recoverable fundamentals, bought in at a discount, restructured the operations, and either sold or held for yield. It was boring work if you didn't love it. I loved it. I moved into a condo on the 43rd floor of a building in the West Loop. I didn't tell my family. Not because I was hiding. I just knew the conversation would go the same way it always had. My father would ask about Nathan. My mother would say she was proud in the quiet way she had, the way that always felt like an apology for something she hadn't done, and Nathan would make a joke that wasn't quite a joke. I visited for Thanksgiving that year. Nathan was there with his wife and his business partner, a guy named Greg who wore the same brand of loafers my father wore and laughed at all the same moments. Nathan's company, Hartwell Logistics, had grown. He had 40 employees, a warehouse in Cincinnati, a new fleet of freight trucks. My father talked about it for most of the meal. Someone asked me what I was doing in Chicago. I said I worked in finance. Nathan said, "She means she looks at spreadsheets for someone else." Everyone laughed. I took a bite of sweet potato. What I didn't say was that Meridian had just closed a $22 million acquisition of a struggling freight and distribution company in the Southeast. I didn't say it because I didn't need to. I filed it away instead. The trouble started about 8 months later. Nathan called me on a Tuesday night. He never called me unless he needed something, and I had known that since I was 12 years old, so I let it go to voicemail. He called again. I answered. Hartwell Logistics was in trouble. He'd overexpanded. The new warehouse lease in Indianapolis was bleeding him. One of his major clients had pulled a contract without warning after a shipping delay that, according to Nathan, wasn't his fault. He needed liquidity. He needed it fast. He was asking me for money, not as a gift, as a loan, he said, short term. He just needed to bridge a gap. 60 days, maybe 90. He'd pay me back with interest. I asked him how much. He said $250,000. I was quiet for a moment. He said, "Vivian, I know we're not close, but you're my sister. I don't have anyone else to ask." That part was probably true. That's the thing about Nathan. Every lie he told was wrapped around something real. I said I would think about it. I didn't just think about it. I pulled Hartwell's public financials. I called a contact at the bank that held their commercial line of credit. I looked at the lease on the Indianapolis warehouse and the terms of the contract they'd lost. What I found was not a company experiencing a short-term gap. What I found was a company with a structural problem, too much fixed cost, too little margin, and a leadership style that had mistaken growth for strength. But I also found something else. The warehouse in Cincinnati, the fleet, the equipment. Collectively, if you knew what you were looking at, there was real asset value underneath the operational mess. I called Nathan back. I told him I would lend him the money, but not as an informal loan between siblings. I wanted a formal promissory note, a fixed interest rate of 6% annually, and a security agreement that pledged his Cincinnati warehouse and fleet as collateral. I would be listed as a secured creditor on the debt. All of it would be documented and filed properly. He laughed a little. He said I sounded like a lawyer. I said I sounded like someone who had worked in finance for 9 years. He agreed. He signed everything. I wired him the money. I did not tell my father. Nathan used about $60,000 of it to cover payroll and stabilize the Indianapolis lease. He used another $40,000 on operational expenses I couldn't track specifically. And then I found out later, piece by piece, he spent nearly $80,000 on a vintage 1972 Porsche 911 that he parked in his garage and drove on weekends. He did not tell me about the Porsche. What he did do, 6 months after I wired the money, was stop making payments on the note. The first missed payment, I sent a notice. Professional, calm. Reminder that payment was due, please remit by the end of the business week. No response. Second missed payment, I sent a formal notice of default. Certified mail. I also had my attorney send a corresponding letter. Nathan called me that night. He said I was being unreasonable. He said the business was still struggling and I needed to give him more time. He said I was his sister and I was treating him like a bank. I said I was treating him like someone who had borrowed $250,000 and signed a legal agreement. He said our father was going to hear about this. I said, okay. 3 days later, my father called me. He did not ask for my side. He told me I was being vindictive, that I was using money to control Nathan because I had always been jealous of him, that this was exactly the kind of thing he expected from me. His words, verbatim, were, "You have always been the problem in this family, Vivian. Always." I held the phone for a moment. I said, "I'll talk to you soon, Dad." I hung up. I called my attorney the next morning and told her to begin formal collection proceedings. What happened next is the part that still feels a little unreal when I think about it, even now. Nathan, apparently advised by his own attorney, decided that the best strategy was to challenge the validity of the security agreement. His position was that I had coerced him into signing under financial duress, that the terms were predatory, and that the entire arrangement should be voided. His attorney also filed a counterclaim alleging that I had misrepresented myself as a licensed financial advisor when I structured the loan, which was not only false, but provably false, given that private loans between individuals don't require any such licensure. Then my father decided to get involved in a way I hadn't anticipated. He called me twice more, both times with Nathan on the line. The second call, he told me he was going to have me declared financially incompetent. He said he had spoken to someone, a doctor he implied, who could attest to erratic financial behavior on my part. He said the loan I had given Nathan was evidence of poor judgment, that no rational person would lend money to family without proper protections. I almost laughed. The entire point was that I had gotten proper protections. The security agreement existed precisely because I had been rational. I didn't say any of that. What I said was, "I'll see you in court." The hearing was scheduled for a Tuesday morning in February at the Cook County Courthouse in Chicago. It was a civil matter. Nathan's challenge to the security agreement, combined with his counterclaim, and my corresponding motion to enforce the note and foreclose on the collateral. My father had inserted himself as a supporting declarant in Nathan's filing, submitting a written statement about my alleged instability. I wore a charcoal blazer and a white blouse. I got there 20 minutes early. I sat at the plaintiff's table and I opened my folder and I reviewed my documents, even though I had reviewed them so many times that I could have recited them from memory. Nathan came in with his attorney, a man named Garrett, who had the slightly overconfident energy of someone who had won a few cases he shouldn't have, and built a self-image on it. My father came in behind them. He looked at me the way he always had, like I was a question he'd never found worth answering. The judge was the Honorable Patricia Caldwell. She had been on the bench for 14 years. She had a reputation for short patience with procedural games and long patience for well-organized evidence. Garrett opened by arguing that the security agreement was unconscionable, that my brother had signed it under financial pressure that amounted to duress, that I had exploited a familial relationship to extract an unreasonable instrument, and that the court should void the agreement and reduce my claim to an unsecured debt, which, given Hartwell's financial position, was effectively worthless. My father, sitting in the gallery, leaned forward when Garrett finished speaking. And then Nathan stood up. His attorney hadn't asked him to stand. Garrett actually reached out and put a hand on Nathan's arm, but Nathan shook it off. He looked at Judge Caldwell and he said, "Your Honor, I need to say something." Judge Caldwell looked at him over her glasses. She said, "Mr. Hartwell, you have counsel present." Nathan said, "I know, but this is my sister we're talking about, and I think the court needs to understand what kind of person she actually is." Judge Caldwell's expression did not change. She said, "You have 2 minutes." What followed was 2 of the longest minutes I have experienced in a professional setting. Nathan told the court that I had always been financially reckless, that I had manipulated him into a bad deal, that I had a history of erratic behavior he could speak to personally, and that my father, he gestured to the gallery, could corroborate that I had never been stable. He said the word unstable 3 times. He said I had always had problems. I did not look at my father. I did not look at Nathan. I looked at my folder. When Nathan finished, Judge Caldwell was quiet for a moment. Then she looked at Nathan's attorney and said, "Counsel, can you provide the court with the basis for your client's characterization of the plaintiff's financial judgment, specifically the claim that the loan was evidence of poor judgment, given that the plaintiff appears to have secured the loan against identifiable collateral?" Garrett said they had a declaration from the plaintiff's father attesting to a pattern of behavior. Judge Caldwell said, "I'd read the declaration. It contains no specific financial incidents, no dates, no documented transactions. It is essentially a character opinion from a family member. Do you have anything more substantive?" Garrett said they were prepared to argue the duress claim on its merits. Judge Caldwell turned to me. She said, "Counsel for the plaintiff, you may respond." My attorney stood. She walked the court through the timeline, the loan request, the documented financial analysis I had conducted prior to agreeing, the promissory note, the security agreement filed with the Illinois Secretary of State's office, the notices of default sent via certified mail. She then introduced 3 exhibits: the security agreement itself, the filing confirmation from the Secretary of State, and the UCC-1 financing statement that had been on public record since the month the loan was made. The UCC-1 financing statement. That was the piece Nathan's attorney had apparently not looked for. A UCC-1 is a public filing. It's how a secured creditor establishes priority over specific collateral. I had filed one the week after Nathan signed the security agreement. It was on the public record. Anyone who had done even basic due diligence before bringing this case would have found it immediately. Judge Caldwell looked at the UCC-1. She looked at Garrett. She said, "Counsel, were you aware of this filing?" There was a pause that lasted about 4 seconds. In a courtroom, 4 seconds of silence is a very long time. Garrett said they had been in the process of reviewing all relevant filings. Judge Caldwell said, "This filing establishes your client's plaintiff as a first priority secured creditor against the Cincinnati warehouse and the associated equipment fleet. That means in any bankruptcy proceeding or any liquidation, she is first in line. The collateral does not become available for other creditors until her claim is satisfied. Do you understand the implication of that for your counterclaim?" Garrett said he would need a moment to confer with his client. Judge Caldwell said he could have 5 minutes. In those 5 minutes, Nathan turned to Garrett, and they had a conversation I could not hear but could partially read from Nathan's expressions. First insistence, then questioning, then something that looked a lot like the realization that the ground had shifted beneath him. My father sat very still in the gallery. When the 5 minutes were up, Garrett stood and said they were withdrawing the counterclaim. They would focus solely on the duress argument regarding the security agreement. Judge Caldwell spent the next 40 minutes methodically disassembling the duress argument. She noted that Nathan had retained his own counsel before signing the security agreement, documented in the file. She noted that the interest rate of 6% was below the market rate for comparable distressed borrower commercial loans. She noted that the terms gave Nathan a 60-day grace period before any default notice could be issued, which was generous by standard commercial lending practice. She noted that he had made 2 payments before stopping, which demonstrated his understanding of and initial compliance with the agreement. She ruled in my favor on every point. The security agreement was valid. The default was established. I was entitled to foreclose on the collateral, the Cincinnati warehouse, and the equipment fleet to satisfy the outstanding debt plus accrued interest and legal fees. Nathan sat very still when she finished reading the ruling. Garrett was already packing his briefcase. My father stood up in the gallery. He said, "This is not right." His voice was loud enough that Judge Caldwell looked directly at him. She said, "Sir, you are in a courtroom. Sit down." He sat down. I looked at Nathan then. Not to gloat. I want to be honest about that. I didn't feel the satisfaction I thought I would feel. What I felt was something more like exhaustion, and underneath it, something older and heavier that I didn't have words for yet. What I said to him quietly after the judge had left the bench and people were moving around us was this: I gave you a real chance. You had the money. You chose the Porsche. He didn't say anything. I picked up my folder and walked out. The collateral process took about 6 weeks. My attorney coordinated with a commercial real estate firm that appraised and ultimately managed the sale of the Cincinnati warehouse. The equipment fleet, 14 freight trucks and associated loading equipment, was liquidated through a commercial auction. The total recovery satisfied the outstanding principal, the accrued interest, and the legal fees, with a small remainder that I had my attorney return to Nathan in a check. I didn't keep $1 more than what was owed. My mother called me 2 weeks after the hearing. She had heard about it from my father. She said, "Vivian, did it have to go that far?" I said, "He stopped paying, Mom, and he signed the agreement." She was quiet for a moment. Then she said, "Your father is very upset." I said, "I know." She said, "He said some hard things." I said, "He said some hard things." I said, "He did. He's said hard things for a long time." She didn't have an answer for that. We stayed on the phone a little longer, not saying much. Before she hung up, she said she loved me. I said I loved her too. I meant it. I don't know what Nathan is doing now. I heard through someone at a family gathering I didn't attend that he's restructuring, that he closed the Indianapolis warehouse, that he's operating leaner. Maybe he'll find his footing. I genuinely hope so. Not because he deserves my goodwill especially, but because I remember what he was like before the money and the fleet and the self-importance. When we were just 2 kids in Columbus and he used to let me sit in the front seat when our father wasn't looking. People ask me sometimes, when I tell parts of this story, why I didn't just forgive the loan, why I didn't let it go, keep the peace, avoid the whole thing. I always think for a second before I answer. What I say is, forgiving the loan wouldn't have been forgiveness. It would have been the latest in a long line of confirmations that I didn't matter, that my judgment didn't count, that the money I had spent 9 years building could be taken from me without consequence. Because I was the quiet one, the background one, the one who could be dismissed. The security agreement wasn't about money. It was about being taken seriously. And the day Judge Caldwell looked at Garrett and said, "Were you aware of this filing?" That was the first time in a long time that I felt like the answer was yes. I've thought about that courtroom a lot since February. Not the ruling, though I think about that too. I think about the 4 seconds of silence after Judge Caldwell asked Garrett whether he'd been aware of the UCC1 filing. 4 seconds doesn't sound like much, but in that room, in that silence, I felt something settle that had been unsteady for a very long time. Here's what I've come to understand about what actually happened, not just legally, but in the larger sense of how things play out when people make consistent choices over years. Nathan didn't lose because I was smarter than him. He lost because he had spent his entire adult life in an environment where confidence substituted for competence, where charm covered the gaps, where someone, our father, a bank, eventually me, would absorb the consequences of his decisions before they fully landed on him. That's not a character flaw you're born with. It's a habit that forms when you're never really asked to reckon with what you've done. Every time my father redirected praise toward Nathan, every time a shortfall got quietly papered over, it reinforced the idea that Nathan didn't need to build anything solid underneath him. He just needed to project certainty loudly enough. And my father, I've had to sit with my feelings about him carefully because it would be easy to reduce him to a villain and move on. But I don't think that's honest. I think he genuinely believed he was helping Nathan by believing in him so completely. He just never considered what that cost the rest of us. The cost to me, specifically, was spending most of my 20s trying to prove something to a room that had already decided I wasn't worth watching. And here's where the cause and effect gets interesting. That invisibility is exactly what let me build what I built. Nobody scrutinizes the quiet one. Nobody asks the background daughter to explain herself at Thanksgiving. I filed a UCC1 and nobody in my family even knew what that was. The intelligence part, the finance, the filing, the documentation that came from years of unglamorous, consistent work. I didn't have a single moment of brilliance. I had thousands of mornings where I read things I didn't fully understand yet and kept reading until I did. That's not exceptional. That's just what it looks like when you decide that understanding your field is non-negotiable. But the part I'm most grateful for, looking back, is the decision I made not to stay angry. Not because anger was wrong. It wasn't. It was completely rational. But because I recognized early that anger directed outward was energy I wasn't spending on myself. Every hour I spent being bitter about Thanksgiving was an hour I wasn't spending learning something that would matter later. That's not a philosophy I read somewhere. It's just something I noticed about myself and decided to act on. What I want to say to anyone who's sitting where I was sitting 10 years ago, dismissed, underestimated, tired of being the one who doesn't get the dinner party, is this: the documentation matters. Build the real thing. File the paperwork. Let the record speak when the moment comes. Because when Judge Caldwell looked across that courtroom and the silence filled the room, I didn't have to say a single word. The UCC1 said it for me.